and I'll go into that. It's no longer enough for a plaintiff to go in and say, you're the owner? Yeah. You're the GC? Yeah. You're the statutory agent under Russin versus Pisciano? Yeah. Scaffold fell? Yeah. Okay. Thanks. See you on the summary judgment motion. Likewise, it's no longer enough for a defendant to concede anything. Because if defendants take good depositions, they have a good shot at, if not winning these motions on summary judgment, creating questions of fact and getting these cases to a jury. And you got to be aware of that. There's a very important statement in Blake for both defendants and plaintiffs, and it's imperative that everyone understand this. The court stated, and I'm quoting, a defendant is not liable under Labor Law 241 where there is no evidence of violation and the proof reveals that plaintiff's own negligence was the sole proximate cause of the accident. It is conceptually impossible for a statutory violation which serves as a proximate cause for a plaintiff's injury to occupy the same ground as a plaintiff's sole proximate cause for the injury. Thus, if a statutory violation is a proximate cause of an injury, the plaintiff cannot be solely to blame for it. Conversely, if a plaintiff is solely to blame for the injury, it necessarily means that there has been no statutory violation. What does that mean? It means that if a plaintiff proves to us that a scaffold, ladder, or other enumerated device under 240 was not properly secured, was not properly placed, plaintiff's conduct can't be the sole proximate cause of the accident because you can't have concurrent causes. Then we're getting into general negligence principles and set-offs for culpable conduct, and the law still is, as set out by the Court of Appeals in 1985 in Bland versus Manachurian, contributory negligence is still not a defense to a 240 cause of action. So if a plaintiff is able to establish a violation of the statute, you're not going to win on sole proximate cause. That's why I said before, these are really misuse cases where you have a superseding event. So in these situations, depending on proof, these situations where the plaintiff can show a statutory violation, depending upon how good a job a defendant does during discovery and certainly on depositions, plaintiff's either going to win his or her summary judgment motion, or, and we've all seen this, there'll be a question of fact, and the defendants at least get to present their case to a jury. Now, Brian Shute, in the course book, and again, those of you who've heard Brian speak at his decisions course, he puts in these pick the decisions. And I spoke to Brian, who I know for a long time and have the utmost respect for. I said, hey, Brian, I love your pick the decisions. I read them, and I obviously know the cases. You mind if I use them? Because I think they're going to be very illuminating for everybody. And of course, Brian, being the gracious man he is, said, be my guest. So go to page 81 of the course book, which, page 81, which is pick the decision number 2, okay? And this is based, and some of you may, I don't want anyone raising their hand when I ask the question if they recognize this case, but no, you can. But this is based on a recent case decided in 2008. But here's what it is, and I want to read it to you, and let's see what the decision was. Plaintiff was a window washer In order to wash the interiors of the windows, she stood on the desks in the office building, a practice also employed by plaintiff's co-workers, allegedly with the knowledge of their supervisor, and I added some facts from the case. As she was moving along the width of the desk, she fell off. As she's cleaning the window, she falls off the desk. Defendant blamed plaintiff for not using a two-step stool that was purportedly somewhere on the site. Yet it was unclear, A, whether the step stool would have been provided to plaintiff had she asked for it, and B, whether the stool would have been adequate and safe for the task at hand. Plaintiff, who seeks summary judgment, argues that she is merely obligated to show that the tool given her, the desk, was unsafe, that it is the defendant's burden to establish that there was an available and safer alternative, and that defendant failed to create a triable issue of fact. Defendant also seeks summary judgment, argues that plaintiff bears the burden of proving that the owner failed to provide a safe alternative means of elevation, and that plaintiff failed to create triable issues of fact. Now, here's your choices, okay? And let me go through them and let's see who thinks what the court came up, who guesses who guesses correctly what the court stated. 1, the sole proximate cause defense fails as a matter of law. Plaintiff's burden was merely to show that the so-called safety device she had been provided, the desk, was unsafe. This was obviously the case. Further, while the evidence regarding the sole proximate cause defense is unclear, this lack of clarity is not the result of conflicting factual allegations. Rather, it is because defendants failed to set forth any evidence regarding the availability of the step stool. Okay? That's number 1. Here's number 2. Defendant is entitled to summary judgment. It is beyond cavil that plaintiff must prove, and yet utterly failed to prove, that defendant failed to make a safe means of elevation available for plaintiff's use. That's number 2. Number 3, both motions should be denied, because the burden of showing that an elevation-related risk exists and that the owner or contractor did not provide adequate safety devices falls upon the plaintiff. But because it was unclear that a step stool would have been provided had plaintiff so requested, and because plaintiff had not met her burden to establish that a step stool would have been inadequate, questions of fact were presented. Okay, let's have a show of hands. Who thinks, number 1, the sole proximate cause defense fails as a matter of law is the correct, or at least the decision that the court came down with? Who thinks that's the one? You got about 4 or 5 people. Okay. Now, 2 is defendant is entitled to summary judgment. Let's have a show of hands. Who thinks that's the case? Nobody. 1, 2. All right. I'm going to remember both of you. 3, both motions should be denied. Who thinks that should have been the decision, or was the decision? Okay, we got probably 20 hands up here. Okay, the answer is, number 1, the sole proximate cause defense fails as a matter of law. And these facts are based on a case by the name of Furlukaj versus Goldman Sachs. It's at page 111. And let me tell you something for all you defendants out there. I read this decision, I say, someone, and I'm not criticizing anyone, didn't do what had to be done from a defendant's standpoint. By the way,